what I'm interested in is whether you think the Supreme Court is going to take this and what you think they'll do with it.
Well, the reason why I mentioned about the criminal cases is there's a whole host of these 18 USC 922G cases, percolating through the system. That, of course, is the prohibited person aspect of federal law. And there's a whole mess of these coming up under the different provisions. In fact, the Third Circuit Court of Appeals we mentioned earlier in the Range versus Garland case is a prohibited person case. Right. So really, see, what I suspect is going to happen is in the next 6 to 8 months, there's going to be a series of these cases are going to find themselves at the cert petition before the U.S. Supreme Court. And it's not unusual for the court to look at a series of similar cases and try to pick what they consider to be the best vehicle for setting law in America. Because as you know, the United States Supreme Court, as a general matter, is not just about who wins the case. It's also about what precedential value can be set, what teaching value can be set by a particular case and its opinions. And, that is a major factor in when the Supreme Court decides whether or not to take a case. So I do think the Rahimi case is important, but it's going to be competing with other cases up there as well.
It's not a lock that they'll take that Fifth Circuit domestic violence case, but do you think they'll probably take some sort of prohibited persons case?
I think in the next 12 to 18 months, they are going to take more than one Second Amendment related case. If you look back in time, Stephen, going back decades, it's not unusual for the United States Supreme Court to take multiple First Amendment cases or multiple Fourth Amendment cases or multiple Fifth Amendment cases in a given term. So here with the Second Amendment, they've been taking, you took one case in 2008 with Heller, one case in 2010 with McDonald, one case in 2016 with Caetano, a case in 2022 in Bruin, for example. So you see that spaced out. I think that there's a very good chance over the next, 12 to 24 months, Stephen, we're going to start to see the Supreme Court take multiple Second Amendment cases in a given term to try to flesh out the edge cases, to try to help courts make sure they get it right. Again, it goes back to the Supreme Court is not just about winning and losing. It's also about teaching the lower courts how to follow the law and interpret the Constitution and apply the law going forward all across America. So I think that we're going to start to see multiple Second Amendment cases in a given term in a way we haven't, in the last 50 plus years.
That would make a lot of sense given how much litigation there's been since Bruin came out, and that the government, the federal government is probably going to want the court to take a lot more cases where that hasn't really been the prerogative and up to this point. But another question I have on where you think the court is going to go with, especially some of these prohibited person cases. Obviously there's what Bruin says and how the test is meant to be conducted. And then there's also some of the other things that the court has said in dicta, right, in Heller and in Bruin, and in concurrences like the Roberts and Kavanaugh concurrence in Bruin, that lead me to think at least that they may not always strictly follow Bruin, or at least not the way that you or I might expect a case to come out under Bruin. Do you think, how much do other considerations come into play when you're talking about how the court handles these sorts of things? For instance, the domestic violence restraining order prohibition, or let's say the domestic violence misdemeanor conviction prohibition. These are very popular things. People don't like domestic abusers to have guns, right? But at the same time, are there historical analogs to justify these sorts of prohibitions? I think that's less clear. But I wonder what the court would do in this situation, because for instance, the Kavanaugh and Roberts concurrence, they basically say that shall issue gun carry permitting is perfectly fine, but they don't offer any sort of historical analogs for that process. So, what do you think the practical outcome of these cases is going to be?
Well, I think the practical outcome is that the court, as an institution, likes to do things incrementally. And the example I like to give is you think about the gay marriage, again, which is a completely different composition of the Supreme Court, of course. But if you go back to the 1970s, there's an attempt to make gay marriage a fundamental right. And that requires a series of incremental decisions where they start off with, let's make sure we have a right to privacy. Let's make sure there's a right to sodomy in the case called Lawrence. Then let's make sure you can't discriminate under certain laws against, gays and lesbians in the case of Romer out of Colorado. And you see these precedents build up over time, and eventually it gives rise to the Obergefell case that says there's a right to gay marriage in America. Now, I'm not drawing the analogy here to the Second Amendment, which is actually a text-based right. But the truth is the Supreme Court does like to do things incrementally because it's part of our common law system of case builds upon case builds upon case. And I think that if you want to ask me what is the real purpose of the Kavanaugh-Roberts concurrence, I think what they're really kind of signaling to litigants is to say, look, we don't think a facial challenge to shall issue permitting regimes is really where we're interested in going to next, because there's other things that probably need to get cleaned up in the law first before we look at those items. And I think that's a big part of it. The other thing, though, that's very favorable, the Kavanaugh-Roberts concurrence is not anti-gun in any respect. In fact, there's some very powerful language in there that's going to be very favorable to challenges to licensing divisions where these people are going slow or they're harassing law owners and making them, for example, submit references or employer information or, letters from a family member, this kind of stuff. If you look at the concurrence by Roberts and Kavanaugh, they say there's two problems with New York's may issue permitting scheme. One, of course, is it treats it as a privilege, meaning it's the government gets to decide whether or not you get the gun right, the right to carry the gun. That's the first part. But there's a second equally important thing they talk about. They say that the big thing here is it gives discretion to government officials, and that discretion is not permitted. Now, when the government official is trying to look at a letter of reference, they're trying to look at your social media accounts, they're trying to talk about your mental health or physical records, right? What are they doing? They're exercising their discretion to determine whether or not you can exercise your right. So the Kavanaugh-Roberts decision, in addition to the majority decision, is very favorable because they say that any discretion exercised by government agents in terms of determining who gets the right to carry guns is not permitted. And I think that language actually is going to turn out very favorable to the gun rights community going forward over the next couple of years, because it really is going to take away discretion on the part of government officials to deny us the right to keep and bear arms, which is happening in certain places even to this day, so I hear.
Yeah, that's a very fair point. I just also look at how the court has acted since Heller, and I see a court that's, to your point, moving fairly slowly on some of these things and waiting for, at least up till now, public opinion to lead the way in a lot, maybe not intentionally, but that seems to be how it's come out. Like, Heller says you can't ban handguns. Well, by that point in time, 2008, the idea of a handgun ban was extremely unpopular. It wasn't back in, the 60s and 70s necessarily, but it was by 2008. Same thing for, may issue gun carry, or this idea that you can basically effectively deny people the ability to carry a gun for self-defense, that had been at one point almost completely banned, at least for concealed carry, throughout the whole country. But by last year, no one banned totally concealed carry, and only 8 states had these may issue schemes in place. So, the court isn't necessarily way ahead of public opinion on in those regards to this point. And that's where I wonder, how eager they are to move ahead of it in some of these areas.
I think this court is, if you just step back for a second and look at the composition of the Supreme Court and what they've done since the nomination and confirmation of Justice Amy Coney Barrett. I mean, they've taken on an overturned Roe v. Wade in the Dobbs case. They've taken on affirmative action at the University of North Carolina and Harvard this term. I mean, these are big decisions. They did the NYSERPA versus Bruin case. They have a case called Harper versus Moore, which is a huge case we've talked about on my channel, The Four Boxes Diner, of how important this may be in terms of denying state courts the ability to basically rewrite, legislative maps for federal elections, a very big deal that the progressives in America are very nervous about. So this is a Supreme Court that's willing to follow the law where they think it takes them. And I don't think they're sticking their finger in the wind trying to sense where public sentiment is, because if they were going to do that, they never would have taken like the abortion case, the affirmative action cases, or Bruen or any of these other cases. So I think you're looking at a court that's trying to get it right and bring the Constitution and constitutional rights back to where and restore them to where it never should have left.